and the compilation, my lord, the judgment already handed over, but I made a compilation for
along with the judgment.
Yes.
As per your lordship's leaves granted yesterday.
This is being filed on behalf of the appellants.
Appellants. Plaintiff appellant.
Respondent file করে
As
দিয়েছে।
regards
Respondent already filed earlier.
already filed, ঠিক আছে। তাহলে এটা ওই SA 9 of 2022 তে ওই রেকর্ডে চলে যাবে, এনভেলপে করে এই রেকর্ডে।
And after compilation, all judgments shall be filed.
Your lordship may ask for the typed copy of the plate along with the illegible
Yes,
copy.
এটা
Hearing was
Invest-
concluded yesterday.
on the last occasion, that is yesterday, WBACDCL,
Item number 1 of this.
yesterday, it was item number 1.
Mentioned in the speak.
ওইটাতে দিয়ে দেবেন, মানে যেটাতে সেটাতে দিয়ে দেবেন। Yes.
These two matter, my lord, I, my lord, served the copy upon the learned advocate for the opposite party. Your lordship told me to come at
For inclusion,
yes, for hearing, under hearing.
contested application.
Yes. My lord, one matter I mentioned, my lord, madam also, my lord, your lordship officer also see that I mentioned it, but the matter is not appearing, my lord, till today. It's the urgent matter, my lord. It was hard. There was no interim order. It is against the order challenging in misappeal. My lord, kindly, my lord, the matter.
Let it come afterwards. On 14th it will appear.
I mentioned it, my lord, with notice, but it is not appearing.
শুনুন, ওইটা নিয়ে নিন, নিয়ে ওটাকে 14th এ
আরেকবার
রেখে
করে
দেবেন।
দিন না।
14th এ রেখে দেবেন, এটা মিস যেন না হয়। 14th ডেটটা দিয়ে রাখুন, 14th। It is in the list.
Yeah.
It is included in the list.
No,
It has to be included.
included, newly.
রেকর্ডটা ফাইলটা নিয়ে আসবেন। আদার সাইডে এন্ডোর্সমেন্ট আছে নাকি? Learned counsel, is it contested application? So has it been served upon the other side?
Yes,
ওই তো
previously. When I mentioned a fortnight back with notice to other side, that notice was attached to my mention slip. Yes. ওটা তো আপনি দেখলেন তো জাস্ট নাও ইওর লর্ডশিপ অফিসার ফান্ড না ওটা 1443 যেটা দেখলেন ওটা দেখুন মেনশন আদার সাইডের আছে।
হ্যাঁ, না আগের দিনকে আদার সাইডকে সার্ভ করা আগের দিন সার্ভ আছে তো, ঠিক আছে ঠিক আছে।
হ্যাঁ, এটা আগে সার্ভিস করে দেওয়া ছিল।
ফাইলটা আছে, ঠিক আছে। এটা বরঞ্চ তাহলে দাঁড়ান। Let the record arrive.
My lord.
Thereafter the date will be fixed.
My lord.
Thereafter the date will be fixed.
My lord.
It will be in the first week only, in the week commencing from 14th of September.
Right.
Not 14th, but commencing from 14th of September.
14th or any day thereafter.
Any day thereafter.
Your Lordship, may I be permitted to mention two matters, contested application, hearing matter, Your Lordship, for inclusion. I have served to the other side.
Other side it has been served.
Yes, Your Lordship.
Lordship, kindly allow me to mention one matter under the heading of second appeal, Lordship. Section 5 in connection with second appeal. Lordship, this is for new listing, Lordship. New listing. Newly filed matter, Lordship.
Newly filed.
Yes, Lordship.
আমাদের কি আছে jurisdiction? Second appeal, excluding the claim irrespective of years.
Obliged, Lordship.
What is the matter? What is the matter? Is it second appeal or সেকেন্ড অ্যাপিল, ঠিক আছে ঠিক আছে। দেখো কোনটা কোনটা এটা, এটা তো কন্টেস্টেড তো নয় এটা, ঠিক আছে কন্টেস্টেড নয়। এখন কি অ্যাপিয়ার কাকে পাঠিয়েছে, কাকে পাঠিয়েছে? কন্টেস্টেড তাহলে আদার সাইড অ্যাপিয়ার করেছে, আদার সাইড অ্যাপিয়ার করেছে কি? ওই তো, হ্যাঁ পাঠিয়ে দিয়েছে তো, ঠিক আছে ঠিক আছে ঠিক আছে ঠিক আছে ঠিক আছে পাঠিয়ে যখন ঠিক আছে থাক। ইয়েস, দেখুন ওটা কি মেনশন করছেন উনি, সেকেন্ড অ্যাপিল, ইজ ইট রেডি ফর হিয়ারিং?
Yes, sir.
দেখি দেখি, নো, ইজ ইট রেডি ফর হিয়ারিং?
Hearing করার জন্য ready তো?
Actually, this is pending at the time of the.
Learned Counsel, what is this? If you intend to mention, file a fresh mentioning slip. This cannot be accepted.
Client is not me, I am.
Learned Counsel, you come on 14th at 10:30 and mention it. এইরকম নেবেন না, ঠিক আছে? পরিষ্কার হলে নেবেন, এরকম কাটাকুটি নেবেন না।
My lord, My lord.
Only this time, I am.
Learned Counsel, if it is received today and if not, it will not hamper you because this bench will be available from 14th September onwards. So that's why I mention on 14th during the at 10:30 when this bench is available.
My lord, one hearing was concluded on 24th of August 2026.
Second appeal.
Yes, my
Yes.
lord. My lord, judgment was reserved by your lordship.
Yes.
And my lord, one type copy was being asked by your lordship from us. So I'm providing and it was asked by Friday, so I'm providing today.
ওই রেকর্ডে এটা দিয়ে দেবেন।
Grateful, my lord.
ডাকুন, ডাকুন।
Item number 1.
Lordship, item number 1 and for the petitioner. Your Lordship, the matter has become infructuous. Earlier, the appeal was filed.
দিন। Why it has become infructuous?
Your Lordship, the application was filed regarding an injunction order that was passed there during that period regarding a puja that was to be conducted. Subsequent to that, the matter could not be listed and therefore the time has passed, Your Lordship.
Do you have any instruction in
Yes,
this
Your
regard?
Lordship, I have an instruction mail that was sent by the client to my email ID. Your Lordship, I'm the AOR.
এটা কোন ফাইলটা দিলেন?
Your two name photo.
দিন, ফাইলটা দিন। দিন। You are the advocate on record?
Yes, Your Lordship, I'm the advocate on record.
The learned, ওনার নাম নিয়ে নেবেন, the learned advocate on record representing the petitioner submits that the impugned order
20th January.
was dated 20th of January 2026. and against the said temporary injunction being allowed, the petitioner has preferred the present revisional application. Full stop. Subsequently, with the passage of time, the present revisional application has become infructuous. As such, the petitioner does not want to proceed with the present revisional application. In support of his contention, the learned advocate has provided a mail dated 26th of August
2020.
2026. 26 no, आज कौन सी तारीख आज ये? 28. 26th of August 2026. Full stop. Let the copy of the mail be kept with the record. Full stop. As the petitioner does not intend to proceed with the present civil revisional application, being infructuous, the matter is being dismissed.
Much obliged.
এটা কিন্তু থাকবে, মেইলের কপিটা থাকবে রেকর্ডের সাথে। Next.
Item number 2.
Mitra was not required. Mr. Mitra was not required for today. Only yesterday,
Opportunity to appear before your lordship.
yesterday, the learned
The
advocate from
records
record,
we checked the records. All the lower court records have come.
whether they contain the documents, exhibit.
They do contain the documents and the exhibits. Both
So-
are there in
so
the lower court records.
ready for hearing.
There's only one thing which I had also indicated to my learned senior friend. The paper books do not have the evidence and the exhibited documents.
The paper book was, my lord, prepared strictly on the basis of, my lord, the rules.
Rules.
That is, so far as the second appeal is concerned, my lord, those are not required, but we shall, my lord, keep something ready. We shall give them an
Yes.
advance copy, a formal, my lord.
At the
Kindly-
time of hearing.
Yes.
So, when can the date be fixed?
My lord, we agreed to, my lord, 17th if it is
17th.
convenient to the court.
17. Nin. The learned senior counsel representing the appellants and the learned representing the respondents have submitted that let the matter be fixed on 17th of September 2026. Accordingly, let the matter appear on 17th of September 2026. বলছি যে 17th টপিক কিছু আছে? তাহলে at the top 17th.
I will.
Item number 3.
বাড়ির লোককে তো বললো না পাখটা হালকা করে চালিয়ে দিতে, হালকা করে। ডিসপ্লে হচ্ছে? ডিসপ্লে হচ্ছে ভাই? নিন। this matter was fixed for hearing today as per the submission of the learned counsels representing the appellants and the respondents. But it is astonishing to note that neither the appellants nor the respondents are being represented today. For the ends of justice, let the matter appear. Diary দেখে date বলুন। আর একটু আগে দিন কি বলে 17th তাহলে 18th ও 18th তো মনে হয় না 18th হবে না 17th করুন বুঝলেন 17th of September কারণ ফ্রাইডেটা অ্যাভয়েড করবেন বুঝেছেন ফ্রাইডে আমার ডিভিশন বেঞ্চ নেক্সট
Item number 4.
Before I'm for the petitioner, Lordship had directed me to serve and come back. This is the affidavit of service.
you are for the opposite party opposite party total opposite party
Yes, wife of.
Lordship
Oh,
will recollect this
matrimonial.
matter,
matrimonial
custody matter.
oh custody
Custody matter with regard to visitation. Now, my lord, the order, the portion of the order by which I was aggrieved.
both of you have agreed as regards to visitation
Visitation,
timing
yes,
and
yes,
everything.
yes, yes.
place of
Lordship has rightly recollected.
such a what is the age of the child
6 years, my younger son is 6 years old, the next
That
one
is
is
nine.
9 years. 9 years, my elder son, 6 years down.
the younger
Lordship
son
had younger son, 9 years and 6 years. Now, Lordship had
residing with the mother
mother.
and
That, my lord,
they are residing where
Narendrapur.
Narendrapur and you are residing being the father you are residing
I am the father. I am the father.
with the father
No, the children are with the mother
the children of
in
the mother
Narendrapur.
Achha,
I am the father residing in Murshidabad.
Murshidabad
Now, my lord, the court has permitted me to visit twice on every weekend for 2 hours in the afternoon at a place to which the children are comfortable with as per their convenience.
with both his minor son family twice on every weekend for 2 hours in the afternoon so which day will be preferable
My lord, Saturday, 2 days not required. Saturday,
Saturday.
but my lord, Lordship had specifically directed me to come up with 4 options with regard to 4 neutral
First
places.
of all, first step, Saturday. Is there any problem?
That certainly visitation must be with the father. Whether some Saturday, Tuesday or other things is there, I have to take instruction or the Sunday may be
Well,
possible.
I am a biological father. I am
No, no,
coming
I
down
am
from
a-
Murshidabad to see my
I am-
sons.
Yes,
Let the
that is to
dispute-
resolve this
we have
issue.
to resolve the dispute,
yes,
not
yes.
to enhance. So,
So, if my learned friend is suggesting Saturday, I shall talk with my client. The date Saturday or Sunday, which is
in the
which is-
interregnum,
Well,
this bench will
well,
be available on 14th.
in the meantime, they can the father is visiting his child.
No, I am not
Visiting.
seeing my children.
I am
Why
told-
should I go to her place? No question.
Well,
does not arise.
I am told on instruction I am submit in the last 2-3 occasion father visited
1.5 years, 2 years back. I am not going to see my children in her place. That is the last thing I will do.
So before 14th, my lord, certainly Saturday.
On Saturday, my lord,
On Saturday, within 4 and 2 hours, 4 to 6, or 3 to 5, 3 p.m. to 5 p.m.
whatever my learned friend,
3
3 to
PM,
5, 4 to 6.
On
My lord, fix the
each-
matter and after.
each Saturday within 3 to 5 p.m.
My lordship had specifically.
Now, as regards to the
Venue.
place. venue.
Yes.
I asked my client that whether any park is nearer to his residence or not. She told nearer her residence, one park is there.
In that park, Malad, they can meet.
No, my lord, what I suggest, lordship had directed me to come up with 3, 4, 5
So
options.
first of all,
Hmm.
what is the hindrance in visiting in the park?
My lord, monsoon season, my lord, patchy, my lord, it rains may start at any point of
You
time.
have seen the park.
No, my lord. What I propose, my lord, very near to her residence, there is Wood Square Mall opposite Narendrapur Ramakrishna Mission. Very nice place, nice ambience mall. This Wood Square Mall opposite Narendrapur Ramakrishna Mission, very near to my wife's residence. I do not think she should have any objection with if I meet my children over there. There are other options, but this is the nearest. I have searched it out.
Then in that case, after 14th, if you do not agree to the park today,
My lord, interim order, then lordship may permit. I need to meet my children.
Yes.
That is my primary issue.
if any issues arise, then you mention once again.
Then let my learned friend provide the name of the park and location. Because these areas I am not aware of at all.
I shall communicate my land.
Be kind enough to provide the name of the park and the location. Nil.
And after lordship returns, lordship will keep the matter for further hearing. It's an interim measure, lordship is.
Whether it is required.
I was
Because, monsoon has nearly passed by, and by the mid of September, it will be passing by entirely.
Lordship may record the park, but in the event, my lord, there is no facility for refreshments in the park. I may have to take them to the nearest Domino's or KFC. That is, lordship will kindly permit me to.
Practically, my learned friend is the praying for modification of the order passed by the learned trial judge.
Quite naturally, because I will not meet.
And provide them those articles, food items,
as your lordship desires,
in the park itself.
But my lord, emphasizing on only one condition, they are 9 years and 6 years. Neither my wife or nobody from her family should be present there. I should have a one-to-one interaction with my children. They should not be tutored. They should not be under influence of their mother or any family
certainly
members.
between the father and but
Yes,
I have
yes.
to bring the child.
Yes, but she should not be present at a distance of 4 feet or 6 feet from me.
That feet will also be have
My
to
lord,
mention
I want a free conversation with my children. That is what I am on.
The petitioner, being the father of 2 minor children, aged about 9 years, one namely Ahambir Ghosh.
Ahambir Ghosh and Ayurbir Ghosh.
Aged about?
Ahambir 6 years. My lord, now he's 9 years, and Ayurbir is.
I'm asking about the present age. Ahambir Ghosh, aged about 9 years.
9 years.
And Ayurbir Ghosh, aged about 6 years.
6 years.
That is the equivalent. Sentence bolun. Children, namely aged about eto আর এই aged about কি বলে has been granted permission to meet both his minor sons twice on every weekend for 2 hours in the afternoon. Full stop. By the trial court, full stop. Paragraph, the learned counsel representing the petitioner and the learned counsel representing the opposite party have agreed that the father shall meet his minor sons on each and every Saturday within 3 and 5 p.m. Is there any name of the park?
Nearer to the park of her residence.
কি হলো সেন্টেন্সটা? His minor sons on each Saturday within 3 and 5 p.m. each and every Saturday, within 3 and 5 p.m. at the nearest park, at the nearest park, wherein the opposite party along with her minor 2 children are residing. Full stop. Let this one be the order.
My lord,
As regards to 2 feet or 4 feet, no order is being passed.
Lordship need not. Lordship need
It
not.
does not require good.
My lord, one more indulgence, my lord.
Hmm.
My lord, as on instructions, my lord, I may be allowed to have a over on the phone. I may be allowed to have a video call with my sons on alternate days, my lord. Let there be a reflection with regard to that.
That is not in.
No.
No, everything can be on in an order.
সে করুন আস্তে
After all, they are my sons.
আরে কথা বলতে বলতে হলে করে
My
দেবো
lord, the affidavit of service may be kept on.
Affidavit of service be kept to the record.
My lord, the application is disposed of.
Disposed of.
গেট
Great.
Disposed of.
Item number 5.
Lord, in item number 5, I am appearing on behalf of the petitioner, my lord. My lord, talks of settlement are going on, my lord, between the parties. I am praying for 2 weeks accommodation, my lord.
Nil. The learned advocate representing the petitioners submits that talk of settlement is going on between the parties. As such, she seeks an accommodation for fortnight. Full stop, paragraph. Considering the submission of the learned counsel, learned advocate representing the petitioners, let the matter appear on 17th. Let the matter appear on 17th, and as the copy of the revisional application has not been served upon the opposite party, let as copy of the revisional application has not been served upon the opposite party, let a copy of the revisional application be served upon the opposite party in the meantime. And let the matter appear on 17th. Condition.
Item number 6.
This is the second day. This is the second day when none is representing. This is the second day on which none is representing the petitioner. And there is nobody to seek an accommodation either. In such circumstance, the revisional application is dismissed.
Number 7.
The landlord plaintiff,
You are the landlord.
landlord plaintiff is the petitioner before my lord. An application under order 26 rule 9 was filed. That was allowed by the trial court. Thereafter, the report which was filed by the Learned Commission was turned down. A written objection was filed to the while the report was
Why order 26 rule 9?
for local inspection.
That is not order 26 rule 9.
Oh, my lord, my lord.
Order
Order 39 rule 7.
7.
Order 39 rule 7. Application under order 39 rule
Go
7.
through and submit. Go through.
Page 65 is my application, my lord.
65.
65. That is the order, my lord. Order 39 rule 7. I'm sorry, ma'am.
Yes, order 39 rule 7. Yes,
This is
that
an
was allowed.
that was allowed. When the report was filed by the learned commissioner, the commissioner was appointed, report was filed, commissioner's report was filed, and thereafter,
To execute the local inspection in this suit, as per the points of the petition. Where is the petition?
the petition for order 26, my lord, is that starts at page, the
Where are the
application starts,
learned counsel?
my lord, page 57. Starts at page 57, the application.
59, to inspect the business accommodation of the restaurant
Yeah, that was the main prayer.
of the plaintiff
Hmm.
on the ground floor at the just contiguous southwest side of the suit premises, and take the measurement of the said accommodation of restaurant with its entrance and covering portion of the said restaurant by the suit premises and mode of to inspect the suit premises and take its measurement and mode of use. Contiguous southwest side of the west of the suit premises.
That's the
So not within the suit premises.
within the suit premises,
What
but
is mentioned here? Contiguous southwest
it is
side of the.
lying in the southwest corner of the property. Southwest corner of the property.
Has the commissioner filed the report?
Report has been filed, my lord. The report
Page-
starts at page 67, my lord.
67.
No, the type copy
Where
is
is
that
Where is
type
the
copy starts at page
where is
67A.
the sketch map? Where is the sketch map?
Sketch map, my lord. It's a coffee shop which was there, my lord.
In the field note, there will be a sketch map, and the sketch map will be annexed with the report.
My lord, the
In
sketch
the
map,
sk-
so
the
that's not
Field
what.
note will be part of the commission.
What
commissioner's
happened?
report.
Thereafter, an application under 151 was filed by the defendant, stating that the notice was not properly served upon him, so he could not be present at the time of making the inspection of the property.
Achha.
That was allowed, that was taken, and the report which was filed by the commissioner was turned down by the trial court. Thereafter, finding no other alternative, the plaintiff filed an application 151. Since that 151 application starts at, my lord, page, the second section 151 application. My lord, if my lord turns to annexure H, page 76. The ordering portion, last 4 lines from the bottom, my lord. Since the application on basis of which the inspection commission was allowed has already been disposed of, I do not find any pertinent to reassign another advocate commissioner for holding the local inspection of the parties and liberty to take appropriate steps in this regard.
Yes.
And it was fixed for 11th of April 2025. My lord, the report which was filed, my lord, was turned down. We filed an application under 151. That starts at page 77, my lord. Page 77. Where the prayers are at page 79. Where we have stated that hence it is prayed that the necessary order be passed, giving direction upon the learned advocate commissioner Sri Torun Basu to go to the local and execute the local inspection in the suit as per the points of the petition under order 39 rule 7 of the CPC, and filed in terms of the order dated 8th of August 2024 at the same commission cost, and submit his report afresh for the ends of justice.
No, the report was turned down.
Report was turned down.
It was not accepted.
The report was turned down.
Yes.
Notice was it has been clearly stated in the written objection that the notice was duly served, but the learned advocate who was representing the defendant in the suit could not be present since it was dropped in the letter box. But at the time when he has received the notice, that in the court after the inspection was complete, he was present in
Prior to visiting the spot.
Notice was there. Notice was duly served upon them. It is
Must have
recorded.
been served upon the learned advocate representing the.
And also
before
the
trial
party,
court.
my lord. It is recorded in the order. We filed an application under 151. There was a written.
On which ground it was rejected by not accepted by the trial court?
My lord, that rejection order is at page, my lord, at page 76.
Yes.
Yes.
Where is the ground given for not accepting the report?
My lord,
Defendant does not seem to have got the opportunity to participate in the inspection
ma'am.
commission, since it has been claimed by him that he could not find either the learned commissioner or the plaintiff's advocate at the suit premises when he reached there after receiving the notice.
65 minutes. 70. That was.
Hmm.
So, my submission is that already the commissioner was appointed. I filed an appeal that the same commissioner be reassigned with the work so that he inspection, and it's a suit for recovery of cost, eviction suit.
On which ground?
And the ground is that the same commissioner be, until and unless we have to again we have to file an order 39 rules.
On which ground eviction has been sought for?
Sought for defaulter and for reasonable requirement.
For
These are the
reasonable
two grounds.
requirement.
The reasonable requirement and defaulter in payment of rent. The plaintiff is annexed at page, starts at page. The plaintiff starts at page 11 of the application, my lord.
Nil. Hmm.
And my lord, the impugn order, if my lord takes up the impugn order once,
Yes.
it has been wrongly paginated by.
It has been paginated also.
It has been wrongly paginated. My copy is paginated, the impugn order.
8th of August.
The
Impugn
17th of December 2025.
Why have you annexed the entire order book?
Order sheet, that was a mistake on the
17th
part
of
of.
December 2025.
Is the impugn order, my lord.
Hmm.
Which
Having heard both sides upon the agreement order, had been rejected as the defendant could not remain present. Pertinent to mentioning the procedure of defects in the whole in the commission. The primary plaintiff is having the instrument to defend the vote when the whole role in the next Learned counsel, from the plaintiff, you show that reasonable requirement has been made a ground for eviction.
ground,
The
plain starts at page 11, my lord.
Yes. So paragraph
Paragraph, my lord.
10A.
Tenant.
10A.
It's a tenant. The defendant is the
Paragraph 10B.
10B, my lord. 10B. 10B. Plaintiff is running a business over there.
That the business accommodation of the plaintiff company.
Yes.
Running the restaurant business at the ground floor. Is not sufficient, and the suit premises is blocking at the valuable front portion of the said restaurant, covering 172 square feet in length.
And the plaintiff stays in the first floor of the premises, my lord.
Being aggrieved by and dissatisfied with the order of rejection with the order of rejection of the prayer of reassigning another advocate commissioner to hold local inspection on the basis of same. Oh. Your prayer was
to appoint
to appoint another advocate commissioner to hold local inspection on the basis of same application.
My lord, order
under order 39 rule 7 CPC.
My lord, if my lord takes up my application, the prayers are at page 79, my lord. Prayers 79. Hence, it is prayed that the necessary order be passed, giving direction upon the learned advocate commissioner Torun Basu to go to the local and to execute the local inspection in the suit as per the points of the petition under order 39 rule 7 of the CPC, dated such and such, filed by in terms of the order dated 8th of August 2024. At the same commission cost and submit his report afresh. That is at page 79.
কতদূর হলো? On the basis of self-same application filed under Order 39, Rule 7 of the Code of Civil Procedure. So, paragraph. So the issue is as to whether an advocate commissioner can be appointed on the basis of an earlier application of a fresh advocate commissioner can be appointed on the basis of an application which was made earlier, and the first advocate commissioner having filed a local inspection commission report which has been rejected on the ground of procedural defect. Full stop. The civil revision application is allowed, is admitted, and hearing is to take place involving this issue. Full stop. Paragraph. As the opposite party has not been served with the copy of the revisional application. Opposite party or parties?
Opposite party, only one.
Opposite party has not been served with a copy of the revisional application. Let a copy of the revisional application be served upon the opposite party. Let the matter appear on 21st of September.
I'm grateful.
Serve kore and to file an affidavit
Of service.
On the returnable date. বুঝতে অসুবিধা হয়েছে? যেখানে যেখানে বুঝতে অসুবিধা হয় বলবেন সেটা। Next.
Item number 8.
It will not answer the petitioner. But there is a caveat, my lord. Lord, affidavit of service, though it's already recorded, but my lord,
All on behalf of the petitioner. I thought it will be bifurcated.
Lord, it needs to be hard, my lord. It's initial ad interim refusal. Thereafter, my lord, I got protection before the miscellaneous appellate court. The order of injunction passed in my favor, but ultimately
No, specific injunction.
specific injunction.
Specific injunction.
But ultimately, my lord, at the my lord, temporary injunction, my lord, hearing stage, or rather the miscellaneous appeal, heard out, and I lost. Challenging that, my lord, this present revisional application. My lord, there is a customs, my lord, with regard to holding dikha, my lord, in a particular ashram, my lord. That's the subject matter. My lord, the learned judge found by the customs what is the procedure by virtue of which all these things happened previously. But since there is no rules prescribed with regard to, my lord, this holding of dikha, the learned judge, my lord, went against me. But I suggest, my lord, when the rule is not there, if there is a prescribed rule to do something, then, my lord, the rule will prevail. When there is rule is silent with regard to, my lord, the holding of dikha or something, then the customs will prevail.
Who is the petitioner?
I am the petitioner, my lord.
No. Guru Sangha?
Guru Sangha.
Guru Sangha means?
Sri Guru Sangha, my lord, it's a, my lord, Sangha, my lord, it's a ashram, my lord, that
The ashram is Sri Sri Giridhari Ashram.
that's the sister concern of
And here is
where from, my lord, this, my lord, particular, my lord, performing of dikha that was done.
the mother concern is Sri Guru Sangha.
Sri Guru Sangha. My lord, that's the, my lord, your lordship will get, my lord, from the plaint, page 12 of the first volume. My lord, will get, my lord, the Sri Guru Sangha is the registered charitable society who is the plaintiff before your lordship. Plaintiff, the petitioner.
The procedure as regards to Dikha.
That's
that
the
is the con-
subject matter of the suit. Now the other side is on caveat.
Then
The live stream টা pause করো।
then the learned counsel representing the petitioner, that is শুনুন শ্রী বাদ দিলে চলবে না, শ্রী গুরু সংঘ, শ্রীটা থাকবে, শ্রী গুরু সংঘ submits that the initially at the stage of ad interim temporary injunction, the prayer was refused, which was granted during miscellaneous appeal
By the order
by the-
dated below 9th of May
by the-
2024.
by the appellate forum in Miss Appeal. Thereafter, after the hearing of the temporary injunction, the said order of injunction was vacated. Void order dated
That's the impugned order before your lordship. Order dated 28th of November 2025. Last certified copy.
judgment
Yes, Pilot, it's the
28th of November 2025. Oh. At the interim stage, during the proceedings of misappeal,
I got Millard, I protected by an order of injunction since from
injunction
19
was given, but thereafter, after the final hearing, it was তাহলে ওখানে গন্ডগোল
my
হয়েছে,
appeal
ঠিক
got
আছে?
dismissed.
ওখানে লাস্ট লাইনটা দেখুন, লাস্ট লাইনটা কি আছে? No, at the time of final hearing of the miscellaneous appeal, at the time of final hearing, after the final hearing of the miscellaneous appeal, the said order was vacated and the miscellaneous appeal, being number 57 of 2024, was refused on contest. Full stop. Being aggrieved by and dissatisfied with the said order dated 28/11/2025, the petitioner has preferred the present miscellaneous, present civil division. Full stop. As per the submission of the learned counsel representing the petitioner, the matter involves the procedure being adopted while granting Dikha to the disciples of the ashram, namely
Sri Guru Sangha.
Sri Guru Sangha, which is the sister concerned, the mother, which is the mother concerned. And the sister concerned is Sri Giridhari Ashram, which is the opposite party, one of the opposite parties herein.
Right.
Full stop. The present revision application is admitted and will be heard on this point. Full stop. As copy of the revision application has not yet been served upon the.
Millard, they were on caveat. I have served.
So served.
Yes.
I
I can give a notice.
তাহলে as প্যারাগ্রাফটা বাদ দিন, as none is representing the opposite parties in spite of lodging caveat and having been served with the copy of the revisional application, let a notice be served upon the opposite parties. Full stop. Let the matter And to file an affidavit of service in this regard on the returnable date. Let the matter appear on 22nd of September.
Right. Great.
Item number 9.
Lordship, in item number 9, I am appearing on behalf of the respondent number 1 and 2.
My lord, I'm being late by
Respondent number 1 and 2.
Yes, my lord.
my lord, I'm being late by Miss Julie Chakraborty, my lord. Due to some family emergency, my lord, she left the court, my lord. I'm paying for not today, my lord.
The learned advocate representing the petitioner seeks an accommodation on the ground of the personal inconvenience of her. He is the advocate on record.
No, my lord.
Who is the advocate on record?
Lord, my lord,
You are the
Raj
advocate on record.
Tilak- no, my lord.
Then who is the advocate on record?
Raj Tilak Ghoshal, my lord. She has been briefed in this matter.
Hmm?
She has been briefed in this matter, my lord.
Who is the advocate on record?
Tilak Ghoshal, my lord. Raj
Who?
Lordship, we have received the copy from Raj Tilak Ghoshal.
Tilak Ghoshal, my lord.
But on the earlier occasion, there is no mention of any learned advocate, namely Raj Tilak Ghoshal. It is Miss Jui Datta Chakraborty, Miss Munmun Mondol, Mr. Bidhan Modok.
Miss Julie Datta Chakraborty, she has been briefed, your lordship, in this matter.
কি হয়েছে last কি হয়েছে? Inconvenience of the learned advocate representing the petitioner. Full stop. Consider the submission of the learned counsel. Let the matter appear on 22nd of
I'm
September.
paying for not today, your lordship. Keep it, my lord, and next day, your lordship.
লিখে নিন, as this bench won't be available for the forthcoming fortnight, so the matter is being fixed on 22nd of September.
Obliged, Lordship.
Item number 10.
Item 10, Mr. Chitopriya Ghosh is appearing for the petition. I'm praying for not to, my lord. He's on his legs, my lord.
And I'm not opposing, but my lord, this matter your lordship can dispose it of. Your lordship can keep it, my lord, even prior to your lordship's assignment, because it's covered by Barashat Eye Hospital. Non-deposit of entire my lord consideration amount. Now the law is settled.
Kindly
Now
make
the
it
law
a
is. So my lord, only I rely upon Barashat. Because admittedly, the entire consideration amount along with 10% has not been deposited. On that ground, both the courts, my lord, have dismissed, my lord, the preemption application. Very short point, my lord. I shall only rely upon that judge.
So, let it be fixed on
My lord.
which date?
my lord.
Which date?
My lord, any day.
Any
I'm
date.
just praying for not today, man.
Let it. The learned advocate representing the petitioner seeks an accommodation for this day. Full stop. Let the matter be fixed on 15th. দেখুন তো 15th. ঠিক আছে, না ঠিক আছে 15th.
My lord. Grateful.
Item number 11.
Lordship, I am for the petitioner led by Mr. Shobhan Majumdar. I'm praying for short passover.
Passover at 2:55.
Some
Passover. Next.
Item number 12.
My lord, in item number 12, my lord, Mr. Parashar Baddo is appearing for caveat or opposite party. Well, he is suffering from slip disc, my lord. May I just pray for 2 weeks accommodation.
My lord, firstly, my lord, perhaps are you on caveat? We have served pursuant to your lordship's last order. Last week, your lordship
Opposite
had considered it. There's one opposite party.
Opposite party.
And your lordship was also informed that there is another civil revision. So your lordship had directed
I
that.
consider the submission of the learned counsel, let this revision application and the revision application being number CO. They want the CO 366 of 2026.
That is item 60 in today's list.
366 শুনুন এখানে লেখা আছে এই যখনই না এরকম কিছু থাকবে তখন এটা আন্ডারলাইন করে দেবেন বুঝেছেন এই যেমন ধরুন এই যেমন and the revision on application being number এত be taken up together ঠিক আছে এটা আইটেম নাম্বার 60 হয়ে গেছে ওই কজ লিস্টটা খুলুন কজ লিস্টটা আইটেম নাম্বার 60 এই এটা আইটেম নাম্বার কত 12 আর 60 both will be taken up together ঠিক আছে 12 আর 60 পরপর দেবেন বুঝেছেন
Lordship may fix up any date, my lord, subject to lordship convenience
Lord,
after 2 weeks, my lord.
My lord, I cannot have any opposition to this prayer, my lord. Just 2 indulgences, my lord. One, on the last occasion, your lordship had directed them also to serve a copy of item 60.
as the copy of revision application has not yet been served upon the opposite party
That did not get recorded.
the petitioner is entitled to serve copy of the revision of the opposite party within this week. On the earlier
That did not get recorded in the order.
because
My
they
lord,
are
yes,
not
yes,
present.
yes.
My lord, I'll definitely inform, my lord. I'll ask my learned friend to, my lord, hand
Was
over the
advocate on record?
No, my lord, I am not in this matter, my lord. I am being instructed to, my lord.
Also, no order is being passed,
My lord.
but let a copy of
Lordship, I'll definitely inform, my lord, to
be served upon them
I will definitely inform, my lord.
within Wednesday.
And my lord,
As the
Order is being passed.
yes, yes. And my lord, just one more indulgence, my lord, because we are challenging, my lord, refusal of acceptance of our written statement, my lord. Right now, the trial is at framing of issue stage, my lord. So kindly, my lord, gives one convenient date, my lord, in 2 weeks, as my learned friend wants, my lord, whenever your
Which
lordship.
date?
My lord, as the lordship, please, after 2 weeks, my lord. Let it be on 15th, my lord.
When the date is fixed for framing of issue.
When is the next? My lord, it's not within 2 weeks, my lord. He doesn't know the date, my lord, so I do not want to make that submission. Next date,
As per the earlier order dated 28/2026, let the CO 366 of 2026 be taken up with this revision application. Put it to underline for the বলো আচ্ছা the learned advocate representing the opposite party seeks an accommodation on the ground of personal inconvenience of the learned counsel representing the opposite party. Prayer is considered and allowed, and on consent of both sides, paragraph, and on consent of both sides, let the matter appear on 16th.
As the lordship, please.
16th. তাহলে
Grateful.
এই 329 এবং 366 দুটোই 16th এ আসবে নোট করে নিন বুঝেছেন একদম
Grateful.
Deeply
lordship.
obliged.
analogous ঠিক নয় analogous নয় taken up together analogous নয়
My lord, will your lordship be pleased to take the affidavit of service on record?
yes so affidavit of service be kept with the record হ্যাঁ এখানে থাকবে
Deeply obliged.
না 60 তে করবেন না
Item number 13.
13, I'm for the opposite party number 1. I have a talk with my counterpart in the trial court, my lord. There is a possibility of settlement, my lord, they're going on.
But really speaking, Milord, I don't have any instruction to that effect. Mr. Bhattacharya is submitting. I'm not disputing that. If my lord is eager, Milord, to grant them adjournment, Milord, kindly mention that pendency of this Lord, will not deter to hear out the appeal. It's a 2023 appeal arising out of refusal of my Section 8 application because there is an arbitral clause appended to the agreement. I filed Section 8.
No, Mr. Bhattacharya is saying that there is a talk of
No,
settlement.
I
going-
don't have an instruction.
Let my learned friends take instruction on that, Milord. And Milord, I have also Milord taken instruction that the appellate court is Milord is now vacant.
That's twice, Lord, that's my Lord, misfortune. Twice hearing was done. Twice.
So, if it is kept on 17th or 21st.
Yes.
17th, your lordship keeps it. 17th, your lordship keeps Lord, don't record anything with regard to Lord, the settlement because I don't have any instruction.
No, as per the submission of
As per Mr. Bhattacharya's prayer for adjournment, Milord, your lordship.
No, on that ground.
Yes, yes, yes.
That your lordship record, I don't have any instruction. Yes.
The learned counsel representing the petitioner submits that there's a talk of settlement going on between the parties. As such, he seeks an accommodation. Full stop. Paragraph, the learned counsel representing the opposite parties.
Only opposite party number 1.
Opposite party number 1 submits that in this regard, he does not have any instruction as to whether talk of settlement is going on or not. Full stop. Consider the submission of the learned counsels. Let the matter appear on 17th of September 2026.
Great.
Next.
Item number 14.
14. 14. Not 14 not place the application. This is a written instruction. I'm an advocate on record. The matter has been settled outside the court. My mutual deposit has been filed.
You are the advocate on record?
Fine.
The learned advocate representing the petitioner submits that the petitioner does not intend to proceed with the present civil revisional application. And to that effect, a letter has been furnished. Let the letter be kept with the record. Full stop. As the petitioner does not intend to proceed with the present revisional application, so the revisional application is dismissed for non-prosecution.
Wait.
Item number 15.
Lordship, on the specific instruction of the advocate on record, I am praying for 2 weeks accommodation. The advocate on record is hospitalized currently.
The learned advocate representing the petitioner submits that the learned advocate on record is hospitalized, as such seeks 2 weeks accommodation. Accordingly, let the matter appear on 23rd of September. নাম নিয়ে নেবেন কালকে একটা অর্ডার দেখলাম নাম নেই Next.
Item number 16.
Item number 16, I'm appearing for the plaintiff petitioner in this matter. In this case, Order 6, Rule 17 has been allowed at the hearing stage, final hearing stage. Lordship will kindly argument stages.
Specifically, at the time of evidence or
Evidence completed. Everything is
Evidence
completed.
completed.
Lordship will kindly take the order itself, 19th August, Lordship will kindly take the type copy,
No, which paragraph?
Yes, Lordship will kindly seize. Now the petition dated 21st July 2025 to taking the record of the argument stage is considered and the same is allowed. So, it was at the argument stage. The Order 6 Rule 17 was allowed without giving any reason why this Order 6 Rule 17 was allowed. Now, second thing is that in the record, I have seen two written statements has been filed by the same defendants. Now, first written statement was accepted. That is also I have annexed the order. Lordship will kindly takes at page 30.
Preferred this revisional application
Yes.
against the
Against
order,
the order
allowing the order 6 rule
Yes,
17.
yes. My specific point is that this cannot be allowed.
To the order 6 rule 17, what they had sought for.
They have tried to withdraw their admission in respect to the cross examination. So Lordship will kindly seize.
In which page?
This is the
order 6 rule 17 application.
Yes. Page 45. Lordship will kindly seize proposed amendment at page 46.
Yes.
That after the third word of third line of para 15 of written statement, the word not a will be inserted. Second amendment is that after the word it is in the second sentence of first line para 16 of written statement filed by this defendant, the word not will be inserted. Now Lordship will
Have you annexed the
yes,
statement?
yes. Lordship will kindly takes they sought to amend the written statement that your Lordship will kindly seize at page. Yes.
37.
Page 37. Yes, ma'am. Paragraph 15 and 16. Yes. Lordship will kindly seize the third line of para 15.
It is not a fact.
It is not a fact. But it is fact that Gopal Vishwas had died leaving behind his one son, so and so. Now, another is also at paragraph 16.
Where is the plaint?
Yes. Lordship will kindly takes at page 15 it starts, the suit for recovery of eviction of license.
The second sentence of the first one in paragraph 16. That means 16. In paragraph 9 of the current code. The word after the word it is it is true to say not it is true to say that defendant wanted to make a paranormal contact too. It's true to say that pointed out as caretaker and residential property which is ancestral family dwelling house of the plaintiff. Yes.
Now, my lord.
Lord Counsel, these are denials which they have wrongly not denied.
My lordship will kindly seize, my lord. My lord, I'll take 2 points before your lordship, my lord. If your lordship kindly takes the first written statement they have filed, that is at page 24. Same person has filed. It's not that other defendant has filed. Same person. Lordship will kindly takes, my lord, page 24, written statement on behalf of defendant number 1, Nimai Shonash. Now, lordship will kindly takes, my lord. Yes. My lord, paragraph
Page 35 is the written statement.
They have filed that has not been accepted, but they have sought for amendment of a non-accepted written statement. That is also a point, man. You cannot take that. Man, they have filed one written statement first. Lordship will kindly take this page 25 I'm showing.
Page which is in page 24, that is annexure B.
Yes,
It
annexure
has
B,
been
man, this
filed
was
on-
accepted.
B has been accepted.
Yes, now Lordship, yes, man, accepted on my live annex the order, man. Lordship will kindly takes page 32, 33.
33.
Yes.
1 minute.
Well, ex parte order.
1 minute, 1 minute.
Well, ex parte order.
2015.
Yes, in 2015 it was allowed. Well, ex parte order without rated without cost, my lord, written statement accepted. Plaintiff failed to take initiative. So after that, this has been happened. Now, my lord, lordship will kindly takes, my lord, the written statement they have filed in the first occasion. That is at page 26, para 15 and 16.
1 minute.
And if your lordship sees the wording of para 15 and 16 of the first
1 minute, 1 minute.
yes, madam.
Yes.
Now, my lordship will kindly seize paragraph 15 of page 26.
Yes.
Yes. Now, that the contention made in paragraph 8 of the plaint are not true. It is not true to say that during exclusive right, title, and interest and possession over the suit property, it is fact that Gopal Bishwas had died leaving behind his one son Sushanto Bishwas and 3 daughters. Now, Mala, paragraph 16 also, my lord, that the contention made in paragraph 9, it is true.
But it is false to say that the legal heirs of Gopal Bishwas inherited the suit property, or that plaintiff is paying rent to the state of West Bengal.
Mala, from where your lordship is sitting, my lord?
Paragraph 15.
Yes, my lord.
Third, fourth, fifth line.
Yes, my lord. Well, after it is fact that Gopal Bishwas had died leaving behind one son Sushanto and 3 daughters, Bhajana Modok, Dipali Bishwas and Sadhana Bishwas, but it is false to say that the legal heirs of Gopal Bishwas inherited the suit property, or that plaintiff is paying rent to state of West Bengal. So, well, this is a
contention is this one, whether they inherited or not.
Well, the contention is whatever maybe, my lord. Well, if they are trying to, my lord, build upon the written new amendment application, lordship will kindly see the proviso of order 6 rule 17, my lord, once one of my kind consideration. And the proviso says, my lord, order 6 rule 17, my lord,
let them appear.
Well, very, my lord, the 7th September is the date fixed, my lord, before the trial court. My lord, for one of the arguments, because they have the amendment has been allowed. So it's the final argument stage, my lord. In that stage, I will be seeking a very small period of stay, so that I can come back and stop. It's my suit.
Provide a searching slip, information slip.
Well, I can, but that your lordship can record my submission.
Lynn. The learned counsel representing the petitioner or petitioners?
Well, I am for the petition.
Petitioners.
Yes.
Petitioners submits that being aggrieved by and dissatisfied with the order dated
Yes, my lord.
19/8/25.
19th August 2025.
19th August 2025. The petitioners have preferred the present revisional application. Full stop. Paragraph through the impugned order, the learned trial judge has been pleased to allow the amendment sought for through the application under order 6 rule 17, read with section 151. Read with section 151 of the Code of Civil Procedure. full stop. Full stop. The learned counsel has further submitted, paragraph, learned counsel has further submitted that earlier a written statement was filed and subsequently another written statement has been filed which has also been accepted.
Which has not been accepted, not been accepted.
Not accepted.
Not accepted. Not has been accepted.
1 minute. Learned
Page
advocate-
43,
one minute,
madam.
learned advocate representing the petitioner submits that the first written statement which was filed first written statement which was filed earlier যেটা পারবেন না বলবেন সঙ্গে সঙ্গে first written state learned advocate representing the petitioners submits that the first written statement which was filed earlier was accepted on 27/1
2015.
2015 and subsequently another written statement has been filed by the defendant or defendant
Same defendant, same defendant.
self-same defendant namely
Namely Sonnashi, madam. Nimai Sonnashi, yes, madam.
namely Nimai Sonnashi, which has not been accepted.
Only kept on record. Yes,
where-
page 43.
40, which has not been accepted. Full stop. Pranam.
Only it has been kept on record. It's on 17.
Copy not served that we kept with the record for discuss and the which has not been accepted and the amendment which has been which was sought for was in respect of the second written
Yes,
statement which has not yet been accepted. Full stop. Paragraph. The civil revision application is civil revision is admitted and it will be heard on the point as to whether allowing the prayer of amendment wide order number
94.
94 dated
19th August 2025.
19th August 2025 is in accordance with law or not. Full stop. Okay. Next as no as copy of the revision application has not yet been served upon the opposite parties.
Yes, madam.
Opposite parties.
Party na party?
No opposite
Party.
party. No.
Hello, opposite party, madam.
Opposite party.
Opposite party.
You serve on the you serve on the proformas also.
Proforma, madam, they are
You serve it.
madam, they are probably madam mild legally or something.
Achha.
Only Nimai Sonnashi is the main defendant.
Opposite party. Full stop. And to file an affidavit in this regard on the returnable date. Full stop. Paragraph. Let the matter appear on. Achha. Let the matter appear on. What is it? 21st of September. Full stop. At this stage, paragraph. At this stage, learned counsel representing the petitioners submits that the next date is fixed for argument. Next date is fixed for argument, which is to be held on
7th September.
7th of September 2026. As such, seeks a 6th day of the proceeding of the title suit being number.
It's being number 118 of 2014.
118 of 2014. Pending before the civil judge, junior division, first court at Krishnanagar, Nodia. Full stop. Paragraph. As the petitioners have preferred the present revisional application against the order of amendment which has been allowed by the trial court, and if argument is taken up, then it might prejudice the rights and contentions of the petitioners, plaintiffs, petitioners, plaintiffs, contentions of the petitioners, plaintiffs. In such situation, let there be an interim order of stay till 30th of September or until further order or orders, whichever is earlier. Date 17 দিয়ে দিয়েছেন তো? Next.
May I prefer one indulgence, my lord? Item number 30, I'm just mentioning because, your lordship, the court below the execution proceeding is fixed on Monday and the police has been directed to make a personal appearance before the State Consumer Forum. Item number 30. If I'll wait at 3:30.
Learned Counsel, till date, none had moved as regards the urgency. If that had been moved,
I understand, my lord. If it can be, it is fixed. It's there in the list today.
It's there in the list, but
item number 30.
You could have got the preference. If anybody had moved the urgency, none had moved till date. This is the first time the court is hearing.
I understand, my lord. Kindly, lordship, will at 3:25, 3:28, whatever time, but it's fixed on Monday. Kindly take this order. Kindly have a look at this order. My advocate on record in the before the State Commission has sought for a time on the ground of her marriage.
This date of first of what? Which is the date? Monday. 20.
My lord, Monday, 31st of August.
31st. It was fixed earlier.
Earlier.
On which date it was fixed?
Well, it was fixed on.
So thereafter, since then,
no steps. My lord, I have nothing to say, my lord. I have nothing to say on that, my lord. It was filed. This petition has been filed long back, my lord. The only thing is that.
How can this court take up out of turn?
Well, my lord, it's expertise anyways, my lord. First time it is coming up today. I leave it upon your lordship, my lord. If it is not on Monday at the first.
Monday, this bench won't be available.
This bench
for the forthcoming fortnight.
Yes. But the thing is that, my lord, I have kindly see this order, my lord. Kindly have a look at this order once. Kindly have a look at this order. A decree holder is present in person. My advocate on record prays for time. Time has been sought for in the prayer of the advocate on record. Thereafter, kindly see the next direction. Time being granted, thereafter, kindly see.
There's an interim application pending, which is to be taken up on 31st of August.
I have been directed to be personally present by the OC Durgapur. Kindly have a look at. I am only aggrieved. My appeal. I'll just indicate what is the matter. A complaint was filed in the State Commission. I have lost. I have lost in that appeal. I have lost in that complaint. I preferred an appeal before the National Commission. National Commission rejected it on the ground of delay. My lord, against which the present revisional application has been filed. My lord, in the meantime, the execution proceedings was continuing. I have asked for a stay in of the execution proceedings in the revisional application, my lord. The matter was not taken up, and this was the order that was passed, my lord. Kindly have a look. And I'm only seeking for a very limited. I'll come back after 2 weeks. My lord, kindly personal presence be dispensed with on that day, 31st. I can move the application.
Considering the pros and cons, the concerned forum has fixed 31st of August for personal appearance.
But at personal appearances with the police assistant, police will arrest me. Kindly have a look.
Learned Counsel, you are free enough, you can come to the court personally without the assistance of police.
But I will, my
Let the matter instead of taking up today, the matter will be taken up on, you will get the preference, the matter will be taken up on 14th.
14th, my lord, till that time, my lord, kindly keep by personal appearance abeyance.
No, Learned Counsel.
Kindly, my lord, that if your lordship sees the order of the State Commission, my lord, I can indicate, my lord, I have the dates, I can indicate the dates also. There was no delay.
As regards to stay of the direction,
this is a consequential order. I am asking for a stay of the main order.
You appear before the court concerned. Have the interim application heard of, and to that effect, you will get the weapon that the matter be stayed, but next date be posted after 14th or whatever. But there won't be any stay as regards to personal.
Only,
appearance.
may I seek one thing, my lord. Only one, my lord. My lord, I will be present, my lord, on that day, my lord. This affidavit, no, I will be present in court, my lord. No adverse order be passed on that day. At least that, my lord. Kindly see that, my lord. Lordship has seen the. My lord, let it be on the top on 14th, my lord.
Yes, that you can pray. দেখুন তো 14 টপিক কিছু আছে? কিছু নেই। The matter is
30.
The matter is taken up out of turn. The matter is taken up out of turn, being moved by the learned. You are the advocate on record?
No, my advocate on record is online, my lord.
Acha,
Shweta Mukherjee.
Taken up out of turn, being moved by the learned counsel representing the petitioner, full stop. Considering the urgency, let the matter appear on 14th at the top. In the interregnum, let copy of the revisional application be served upon the opposite parties, and affidavit of service be filed on the next date, on the returnable date. ঠিক আছে? হলো? Yes. Next,
Item number 17.
Let the copy be served and affidavit of service be.
Lordship, I am for the petitioner, Lordship. Lordship, I am late by stubborn. From that term, may I seek for an adjournment?
Not to the next.
Item number 18.
18, my lord, in spite of lodging of caveat and in spite of there is a note of caveat.
Not served.
Not served. But kindly record and my lord, direct my lord, the petitioner to serve a copy so that not on the next day I can make myself prepared. It's section 47 application, my lord, rejected in an execution case. My lord knows.
47 rejected.
Has to be, my lord. My lord knows the real trouble starts, my lord, after getting the decree. সেটা দরকার নেই আমাদের, আমরা কপি দিতে বলি, ওসব ছেড়ে দিন, ওই করে দেরি করে লাভ নেই। It's a 2011 Jamis case, 47 registered in 2011. Today we are in 2026. Gives them a last chance, my lord, so that
the learned counsel. No, this is the first day.
No, my lord, what I suggest
appearing before this bench for the first day.
Oh, very well.
None is representing the petitioners or
petitioners. Petitioners.
None is representing the petitioner. Sanjit Bhomik. None is representing the petitioner.
There are several judgment debtors, but one of them has challenged.
While the opposite parties are being, you are representing both the opposite parties.
Yes, well, decree holder opposite party.
While the opposite parties are being represented.
Lord, I am representing Oshima. Oshima lodged the caveat.
As regards to Oshit Bhuiya, you are not representing Oshit Bhuiya.
No, because Lord, I am the assignee decree holder. Now, Lord, the opposite party number 1 have already transferred it to me.
None is representing the petitioner, while the opposite party number 2, namely ASEMA, Oshima Bibi, is being represented. Full stop. The learned counsel submits that in spite of lodging caveat, copy of the revisional application has not been served upon the caveator. Full stop. In such circumstance, the learned counsel prays for direction upon the petitioner to serve a copy of the revisional application upon the opposite party number 2. The prayer is allowed. Full stop. The petitioner is directed to provide a copy of the revisional application to the opposite to the opposite party number 2. Um, within within 11th of September. Within the 11th of September. Full stop. As full stop. As none is representing the petitioner, let the matter appear on 23rd of September.
Great.
Next.
Item number 19.
19, I'm for the opposite party. Lordship, I don't think the petitioner would be appearing because we have already taken possession in respect of the execution case. We have only come against the order of police.
No order is being passed as none is representing the petitioner.
Number 20.
20 lawsuit.
The opposite party.
I am appearing with the petitioner also. Evidence service lawsuit.
You can ask the chief manager.
Every service. Yes, lawsuit. Lawsuit already was directed to SARF. I already served a copy of the lawsuit. Evidence service.
How many opposite parties are there?
Lawsuit only one.
Only one. So you are representing the opposite party.
Yes. Lawsuit, I am the defendant petitioner hearing lawsuit. Plaintiff file a suit for eviction and recovery of possession as a trespasser under TP Act. Lawsuit. Thereafter, lawsuit, I file an application under sections under Order 7, Rule 11, read with 151 of CPC, paying for rejection of the plaintiff. Defendant plaintiff filed a written objection. After considering, learned trial judge rejected my application for rejection of plaintiff. That is the impugned order. Before placing the impugned order, I place the plaintiff. Lawsuit notes if the plaintiff is lawsuit plain page number lawsuit kindly 10 lawsuit. Subhas Mondal is the
what is missing from the plaint?
Lawsuit.
What is missing from the plaint?
Plaint in the yes no.
It is their petition Order 7 Rule 11. Let them submit. You will get the opportunity.
Yes. Plaintiff claiming that plaintiff admitted that they are the owner of the lot A property, and also in the plaintiff admitted that I am the tenant of plot B. Lot B.
So you are the tenant in respect of lot or plot, whatever lot.
That was lot B.
Lot B.
That was
and they are the owner in respect of
lot A.
Achha,
They praying for recovery.
Have they annexed any map with the plaint, sketch map with the
in
plaint?
the plaint? He is admitted. I is placing that to
is there any sketch map?
Sketch map, no.
With the plaint?
No.
There is no sketch map.
Not annexed. It is not annexed. There is a sketch map with the plane.
I do not know. No sketch map, lawsuit.
Not in where it is mentioned, there ought to be mention of
No,
sketch map.
I do not find any.
It is in the plaint, Your Honor.
Yes, in the plaint. In which paragraph it is mentioned?
Paragraph it is not mentioned.
It is not mentioned.
Or in the last page, in the mention in the document which is submitted, or it has been mentioned, Your Honor.
Well, it could come page 18.
Page number 18. Page number 18, Your Honor.
Point number 5. Building plan lot A.
No, that is lawsuit. I asked for page map of this schedule
Sketch
property.
map is attached with the plane. I have been through the sketch map is attached.
But it is not.
But it is the
It is
title
not
deed.
reflecting from the list of
In the title
documents.
deed, in the title
It is
deed,
this one is list of documents relied upon by the plaintiff.
but in the list of documents there is a title deed, and with the title deed the sketch map is there.
With the title deed, obviously there will be a map.
Map is there. He has not annexed the sketch map.
In the plain, no sketch map, lawsuit. Lawsuit, I place this relevant
paragraph.
1 minute. What is the schedule? Schedule?
Schedule,
One
Lordship.
room on the ground floor.
Yes, yes. Lordship, schedule, kindly come to the schedule.
Entire, is it 12 feet wide?
Common
Common
passage at
passage.
premises number such and such, which is butted and bounded as follows. By premises number 18, Ward Institute Street, partly be premises number 17A, Ward Institution Street, and 17B, Ward Institution. In the east, by premises number 8A, 8B, Rajendra Lal Street. In the west, by lot number B. Lot B of the premises number such and such, the passage and main road. In the plain, they admitted that.
So from the schedule, it is revealing that the room is butted and bounded on the west by Lot B.
Lot B.
So obviously it is, the room is not within Lot B. From the schedule. It is the one room on the ground floor that is being butted and bounded on the west by Lot B. So the room is not within Lot B.
No, it's not within that.
Not within Lot B. Yes.
Lordship, kindly come to the relevant paragraph. Lordship, paragraph number 4.
And where from you will
showing the plane from the plane.
Yes, we show from the plane.
Paragraph 4, Lordship. That
Paragraph
the
4,
plaintiff
yes.
is the younger brother and the defendant is the elder brother in the relation between the parties. The plaintiff is the adjacent owner. Lordship, kindly take note of it.
So you are the full-blooded brothers.
Yes. That the plaintiff, Lordship, kindly paragraph number 5. That the plaintiff is the adjacent owner of portion of Lot B property, which is the defendant illegally occupying at premises being number 15 or such and such.
Adjacent owner of the proportion that is Lot B, which the defendant illegally occupied. Acha.
That means, Lordship, defendant is occupying the Lot B property. Next, Lordship. That the plaintiff was purchased the plot of land in lot A in the year of 2014. Premises number such and such.
Yes.
In the plain, he is admitted that he is the owner of the plot A, and I am possessing illegally the Lot B. Lot B owner is not made a party in the suit. Next paragraph, paragraph number 12. I only relevant paragraph 12.
One minute, Lord. Lot B. Not A. Yes. The younger brother of the defendant, the elder brother. The defendant is the elder brother. Plaintiff is adjacent owner of this portion. The plaintiff is adjacent owner of B. Plaintiff. Younger, elder, dependent. Yes.
And schedule also already seen that schedule mention lot number A butted by the lot B. And he also admitted that I am possessing the lot B. And he is the owner by purchase lot A. Thereafter, Lordship, paragraph number 12. That the defendant is making iron plate from the machine which was purchased jointly by the plaintiff and the defendant, and the present defendant is trying to sell the
plaintiff is the younger brother, being the owner of Lot B.
Plaintiff owner of the Lot A. Paragraph number 6, Lordship. Kindly see. Paragraph number 6.
Paragraph number
6.
The plaintiff purchased the plot of land lot
Lot
A.
B.
No, the plaintiff purchased the plot of land that is lot A.
Lot A.
Lot A.
And paragraph number 5, the lordship. Plaintiff is the adjacent owner of
Plaintiff is the adjacent
owner of portion of lot
lot
B. Lot B, the plaintiff claiming that I am the possessing the lot B. That was not the ownership of the plaintiff. Another ownership is there. That owner was not a party, made party in the suit. Paragraph number 12.
Yes.
That the defendant.
Yes. No, Caleb, if anybody is willing,
Both parties there, then you are.
otherwise not.
That the defendant, lordship, paragraph 12, that the defendant is making iron plate from the machine which was purchased jointly by plaintiff and the defendant. At the present, defendant is trying to sell the machine to the third party without any permission of the plaintiff. And the defendant is also trying to sell for property, that is one room, which is the defendant is illegally occupying the ground floor, that is such and such. Lordship, kindly take it. Even if the defendant trying to sell out this property to the third party, a tenant cannot be sell out this property to anybody. Even if plaintiff claim, plaintiff is not a owner of this property. He also saying that he is not a tenant of this property. Paragraph number 13, lordship. According to provision of law, the defendant has no right to sell the machine as well as one room of the ground floor, ground floor at such and such premises number. Next, lordship, relevant paragraph 17. That at present the defendant is creating the dreadful atmosphere over the schedule mentioned property and trying to sell the machine and also trying to sell the room with some muscleman agent of the locality without permission of the plaintiff.
Yes, now come to the prayer portion, 1 minute.
Lordship. Prayer of the plaintiff.
A decree declaring the right title and interest of the plaintiff in the suit property.
Right title interest of the plaintiff in the suit property. Suit property is claiming the purchase property lot.
Yes.
I have no difficulty. A decree of eviction of defendant, trespasser and recovery cash possession in respect to the aforesaid trespasser portion of the plaintiff.
No, Caleb, suit property means the room, which is the
that was purchased by the plaintiff.
That a decree declaring right title and interest of the plaintiff in the suit property. That is one room on the ground floor.
That was purchased property. I have no. Next, lordship, B. A decree
for eviction of the defendant.
Eviction of the defendant trespasser and recovery of cash possession in respect of the aforesaid trespasser portion of the plaintiff. Admittedly, I am not not possessing that portion.
1 minute. Adjustment on the portion of lot B. Defendant is occupying a premises being number 15. Yes.
B, lordship. Admittedly, they himself admit that I am possessing the lot B. He is the owner of lot A. Then, lordship, kindly come to my application. Lordship, page 19.
Trying to include the common passage as well as open space of lot.
Page 19, my application. Paragraph number 3. The defendant was inducted as tenant by the landlady, namely Joya Mathur, since 1995. Joya Mathur is the owner of lot B. In respect of one room with common passage and all easement right lying situated such and such. Next, lordship, paragraph number 5, lordship. That the defendant used to run one business under name style such and such at thereof for the purpose of workshop of non-food items, leather jobs after obtaining one trade license from the Calcutta Municipal Corporation. Thereafter, lordship, paragraph number 6, that that the defendant purchased one machine for his business purpose since 1999 from the market, and the defendant had installed the said machine in the said tenanted room. Paragraph number 8 loss. That the defendant is a senior citizen and he has been suffering old age, various disease, and for the such reason the defendant is unable to run his business, and the defendant made a proposal to the landlady, namely Joya Mathur, to surrender his tenancy. And after considering all aspects, landlady, namely Joya Mathur, has accepted the proposal of the defendant. Thereafter, thereafter the defendant has surrendered his tenancy to the landlady, namely Joya Mathur, by an agreement for surrender of tenancy dated 20th December 2024. Defendant already surrendered his tenancy in favor of the landlady. Suit was filed in the year of 2025, April 2025.
After 4 months.
After surrender of my tenancy. Then how I against my suit is maintainable? I also annexed the agreement of surrender, and also I annexing the rent receipt. Loss pay I started for 25. 25 last portion Joya Mathur signature. 26 also Joya Mathur. Page 30 electric bills in my name. 31 is the tail license in my name. Thereafter 32 my surrender of tenancy in favor of the landlady. If I am already surrender my tenancy in favor of the landlady, how this suit is maintainable against me? I am not a tenant. I am not a trespasser. Nowhere.
Yes.
And admittedly, plaintiff admitted himself admitted in plain, he is the owner of the lot A. I am the tenant of lot B. Who is the original owner? Joya Mathur. In the plain, Joya Mathur is not made a party.
Place order 7, rule 11.
Yes, boss. CPC the কথা
ছোট সিপিজিটা করে দেবেন, আপনার সিপিজিটা করে দেবেন। এখানে ছিল কোন ভলিউম এটা? এটা ভলিউম 3, এটা ভলিউম 2 টা। Yes.
Yes. Rejection of plain lawsuit. Plain shall be rejected in the following cases: where it does not disclose a cause of action, where the relief claim is undervalued and the plaintiff, on being required by the court to correct the valuation with the time to be fixed by the court, fails to do so, where the relief claim is properly valued but the plaintiff is written upon proper pair insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within time fixed by the court, fails to do so, where the suit appears from the statement in the plain to be varied by any law, where it is not filed in duplicate, where the plaintiff fails to comply with the provision of Rule 9, provided that the time fixed for the court for correction of the valuation or supply the requisite stamp paper shall not be extended unless the court, for reason to be recorded, is satisfied that the plaintiff was prevented by cause of action exceptional nature from the correcting the valuation supply requisite stamp paper. Case one such and such.
Under which clause?
B. Also the lawsuit A, cause of action against my client have no cause of action. Before 4 months, I already surrender tenancy. I nowhere my existence.
Hmm. So you are emphasizing on 711A.
711A and also D.
On which ground?
Statement of the plaintiff. Statement of the plaintiff is admitted that I am not under the plaintiff.
Anything
And
more?
if I relying some judgment, but today I not bring this judgment. If
What
I
judgment is required?
lost, if not
You
required,
can cite the judgment. Refer.
loss.
Refer.
Today I have not bring this judgment.
Get them satisfied.
I want to file the sketch map and also.
No, the sketch map is here.
But,
I have drawn it.
but also.
I have taken the pen to draw the sketch map.
But I want a time for today. Because
That you say, learned counsel.
Because my uncle died in last year. There's a bereavement in my family. So I couldn't go through the book.
Oh. You could have said this at the initial stage only. Name.
He started, so I didn't.
The learned be kept to the record. While today be kept to the learned counsel representing the petitioner submits at length and submits at length full stop. During his submission, the learned counsel has submitted that the lot A was purchased by the plaintiff, while the lot B was purchased by the defendant.
No.
Lot B was not purchased.
I am not the owner.
You are not the owner.
I am nowhere.
So he further that lot A was purchased by the plaintiff, while the suit property, which is mentioned in the schedule, is
also lot A.
Falls within lot A. Being butted and bounded on the west by lot B. Being butted and bounded on the west by lot B of the same premises, that is premises number 1515, comma, ward WARD, ward Institution Street, and a 15 feet passage leading to the main road. Full stop. Learned counsel further submits that the defendant, petitioner defendant, was a tenant in respect of the room situated on the ground floor, which is the
Lot
suit
B.
property. Which is the suit property?
No, suit property. Lot B.
You are not the tenant in respect of the room. That is the suit property.
No, that is my case. Plaintiff purchased the lot A. I am the tenant of lot B, not a suit property.
So the suit property falls?
Lot A.
They are not taking in respect of the room mentioned in the schedule.
Schedule lot A.
Tenant in respect of the room mentioned in the schedule of.
No. That was also mentioned also schedule.
So why you have raised the issue of surrender?
Sir, my
What
lord,
Law schedule, mention of the schedule, that is the lot A, that was purchased by the plaintiff. I am the tenant, lot B, owner of Joya Mathur. That was plaintiff admitted in the plaint. I am surrendering the tenancy in favor of Joya Mathur, my landlady.
Why the story? Why the story of surrendering of tenancy in respect of Joya Mathur arises in this list?
Because of that, lawsuit, plaintiff claiming the recovery of possession from my I already surrendered this possession. How will recovery is maintained?
Last sentence of
Why not the machine, our machine is.
Lord Counsel, you are not submitting. Your submission won't be taken into consideration.
Was a tenant in respect of that room.
No. Kele. Bad din. The learned counsel further submits that the room mentioned in the schedule of the plaint, is situated within lot
A.
He has further submitted that the defendant was a tenant in respect of a room which belonged to Joya Mathur.
Lot B.
Which belonged to Joya Mathur, who was the owner, was the or is the?
Yeah, no, present also owner. Joya Mathur.
Who is the owner of lot
B.
Full stop. He further submits that the defendant is presently not in possession of the said room, as he has surrendered the tenancy in favor of Joya Mathur.
20th December 2024.
On 20th December 2024.
And suit filed April 2025.
And the present list has been instituted during the month of April 2025. LIS has been instituted during the month of April 2025. Full stop. He further submits that by no way this defendant can be implicated as a party in the list. Full stop. The Lord Counsel further submits that in respect of the same, an application under Order 7, Rule 11, seeking rejection of the plaint was filed, which has been rejected by the trial court. Being aggrieved by and dissatisfied with the same, the learned counsel has preferred the present revisional application. Full stop. At this stage, the learned counsel seeks an accommodation to file, to provide authorities in support of his contention. Full stop. In support of his contention. Full stop. Paragraph. The learned counsel representing the opposite party also seeks an accommodation. Accordingly, let the matter appear on 15th of September.
That's the top of the list.
Let it appear on 15th of September.
That's it.
Being partly heard.
Last.
এটা পার্ট হার্ডে আসবে, ঠিক আছে? both of you can provide sketch map. It is up to you. But prior to providing, have the copy of the sketch map exchanged
Yes, ma'am.
between yourselves.
Item number 21.
The petitioner is father of the child. He filed application for
Visitation right.
visitation right. But that is not done, my lord. I serve and come back.
Visitation right has not been allowed,
Not
rejected.
It is not a past order. Time and again, my lord, it is adjourned. Order is not passed on.
Oh, it has not been disposed of.
So it is disposed of.
So you are seeking?
Or visiting right, my lord, once a week or to.
Has the application
Yes,
has the
is
application been
pending.
disposed of or not
It is
disposed
not
of?
disposed of.
So what are you seeking now?
My lord,
What is your prayer?
my lord, for direction, visiting right or direct the learned
How
court,
can that be?
learned
The application is pending before the trial court.
trial court, my lord, if your
So
lordship
how can
direct
this court direct?
to expedite the matter.
What is your prayer in the application?
My lord, interim order.
No. What is your prayer in the revision application or the order? Okay, Article 227.
To allow this application issue to take custody of minor child to meet this minor child once a week.
You are saying that an application is pending before the trial court, and herein you are and that application has not been disposed of, and you are herein you are seeking to take custody of his minor child or meet his minor child.
I'll expedite the interim.
Where is the prayer?
Well, that prayer is not here.
So
once a week or your lordship may deem
one
fit.
thing can be done.
Well, yeah, as your lordship may
Lord
deem
Counsel,
fit,
one thing can be done.
deem fit and
Negative against which will be against you.
only deem fit and against.
Hmm?
Only lordship may deem fit and proper.
Deem fit and proper. Deem fit and proper as regards to your prayer. That is to take the custody of his minor child or meet his minor child.
Kindly be expedite the matter.
In such prayer, it cannot be expedited. The order cannot be passed.
Or may I serve and come back?
What will be the effective result? That is the question mark.
I give direct to serve the
Because the prayer which you are making verbally, that is not made in the application. The prayer in the application is otherwise.
as your lordship may deem and proper. This is of your lordship discretionary power of your lordship.
No. Deem fit as regards to custody or visitation right.
Yes.
Up to that extent only.
Or expedite the matter.
No. Then you have to seek. You will have to seek the said prayer which you are submitting, verbally submitting. Not today. But in this one won't be effective, Learned Counsel.
Can you give me a chance to file a supplementary by praying for
I don't think that will be effective. You will have to file afresh.
afresh? Give me a chance to withdraw that.
Because if you intend to have it expedited, you will have to file afresh. Next.
Not press, my lord.
It is up to you. Consult with your client and come on the next date. Which you are intending to have obtained from this court, that won't be available through this prayer.
Only to expedite, my
Where is that word mentioned in the prayer portion?
lord.
Next.
Item number
Am I
22.
clear? Am I clear? Have you got it?
Yes, ma'am.
Next.
Item number 22.
Next.
Item number 23.
Is there anybody on, in a matter, both sides are present in any matter? In any matter, both sides are present? Name. Both sides are present.
Lordship, item number 33.
Kill him. There's a resolution from that end only. If both sides were willing, then the matter can be taken up.
Item number 33, Lordship. It was the first listed, and it was filed in the year, in the month of January, and till date, no hearing takes place, Lordship. It's a matrimonial dispute matter. Item number 33.
Seeking expeditious hearing.
Expeditious hearing, Lordship. Filed in the year 2024, passed then ordered by the coordinate bench, same stage. Till that suit is in the same stage. That's a